Alrighty, everyone. I believe I have 4 more episodes left of property, and then I'll be done. And then, as far as property goes, then we only have a couple more classes to cover before the end of the semester. As far as these 4 episodes go, we're going to be focusing on land use restrictions, at least for this episode. We'll have a couple episodes about eminent domain, as well as takings, and then I believe there's one more episode that will be related again to land use, just coming back. But as far as land use goes, we talked about some of the private ways that people can put restriction onto their land, and that's going to be typically through easements. Now we're going to be talking about some of the public ways, or I guess this may still be private as well, but we're going to be talking about land use restrictions. And there's 2 main parts of this. We're going to be talking about covenants, real covenants, and then we're going to be talking about equitable servitudes. Along with this, we'll kind of sum those 2 up with how the restatements kind of approached it, and then talk about common interest communities when it comes to ensuring that these real covenants and equitable servitudes are actually being enforced. There's a lot to cover. Even though there's only 4 episodes, these are going to be 4 pretty lengthy episodes just because of how much there is to cover within property. Scrolling down, we still have about a fifth of the content left, and based off of how much I have recorded in my outline. So let's go ahead and get started. Well, how does land use restrictions typically work with a traditional approach? Well, there is a preliminary definition that we need to know, and that's going to be covenants. And we're going to be focusing on real covenants because real covenants and equitable servitudes is the traditional approach. But a covenant is a promise to do something or a promise not to do something with the land. So you have 2 kinds of covenants. You have an affirmative covenant and you have a negative covenant. An affirmative covenant is where you agree to do something. We kind of talked about this with easements. And the negative covenant is when you promise not to do something. So when you agree to do something, you're promising to plant a garden, to grow trees on the property. Or a negative covenant is, I promise not to paint my house this color, or I promise not to plant trees on this property. So now we're going to get a little bit complicated as far as real covenants go. Once again, there are 3 main definitions that we need to know. First of all, what is a real covenant? A real covenant is a promise about how the land will benefit one party and put a burden onto another party. These are going to be the original parties, and whether or not that benefit or burden is going to pass into future successors. And this process is going to be called covenant running at the law. Well, I mentioned 2 other terms there. That's going to be the benefit and the burden. Well, the burden is the duty to perform the promise, or rather to not perform the promise, depending on whether it's an affirmative or negative covenant. And then the benefit is the right to enforce the promise. So we're really going to be, when it comes down to these real covenants, for our analysis, it's important to understand if we're talking about the burden or the benefit, because it's going to shape the outcome of what we're talking about. Okay, so let's talk about this real covenant. And let's talk about future successors. Can this benefit or can this burden pass to future successors? Let's talk about the burden because there's more requirements that go to the burden. First, if we want this burden to pass, then it sounds a little weird. But if we want it to continue, well, we'll say that. If we want this burden to continue with future successors, first, when we draft the covenant document, it needs to be in compliance with the statute of frauds. It needs to have the intent to bind successors. It needs to touch and concern land. And when it says touch and concern land, this is just going to be the executed document. It needs to be related to the use and enjoyment and the occupation of that land. So, for example, building a fence. That fence is on that land, is going to touch and concern that land. It needs to give notice of the covenant to the successor. And then there needs to be horizontal privity. And this privity, as we've talked about before, privity is like this relationship that you have with other parties. And horizontal privity is the relationship that the original parties is going to have between one another. And this is going to be their purchase relationship. So there are 3 ways to prove that you have this relationship, depending on the jurisdiction. The first, depending on the jurisdiction, once again, is that the parties are going to have a similar mutual interest in the effective land. So this is going to be a landlord and a tenant having horizontal privity. We're going to look at whether there's a grantor-grantee relationship. This is, I'm selling you the land. That's as horizontal privity. And then some jurisdictions don't have any requirement for horizontal privity. So those are going to be the 3 main parts of horizontal privity. And then we have vertical privity as the last element that needs to be shown most of the time, depending on the jurisdiction. And this refers to the relationship that future successors have with a original party. So to prove this relationship, all that needs to be shown is that the successor received all of the estate. Once again, as I mentioned, vertical privity is rarely required in most jurisdictions, but it is still part of the bar exam, and so we're going to be talking about it as if it is there. We mentioned these elements. There's 6 that I just listed: statute of frauds, intent to bind, touch and concern, notice, horizontal privity, and vertical privity. Elements 1, 2, and 3, that is statute of frauds, intent to bind, and touch and concern, are also need to be present if we're talking about the benefit to pass to successors. So what do I say when I'm talking about the benefit and the burden passing to successors? Well, we have a case here called Deepwater Brewing versus Fairway Resources Ltd. What happened in this case is that Deepwater Brewing had a whole bunch of land. They had a view over the lake, and there was an orchard between their building and the view of the lake. And this developer, Fairway Resources Ltd., wanted to develop that land in between. And so Deepwater Brewing sold them the land and provided an easement as long as Fairway didn't develop the land so the buildings went above a certain height. They were limited to be lower. So that's your real covenant there. You can see there's burden. The burden on the houses on that property is that there's a height restriction. The buildings can't go higher than 30 feet, 20 feet, whatever it was. We'll say 30 feet just for simplicity. Buildings can't go higher than 30 feet. So there's this burden on that land, this real covenant, this restriction. And who has that burden? Fairway has that burden. Who's benefiting from this restriction? And that's going to be Deepwater Brewing. So we're going to look if there's a violation of this burden. And there was a violation. Fairway built houses that exceeded the 30 feet. And so now does this benefit pass to future interest? And the reason why this was the case is because Deepwater had actually purchased this property after somebody else had already conveyed this to Fairway. So does Fairway still get the benefit working through this? And so now we need to run through this analysis of, does the benefit pass to Deepwater Brewing, a future successor to a previous covenant? And so our steps for analysis is we're going to determine who got what. That's going to be the benefit and the burden. And when they got that for any future privity. So that's going to be benefit, burden. And then we're going to figure out who has that benefit and who has the burden. We just talked about that. Fairway has the burden. Deepwater is seeing if they have the benefit. And then our third step is we're going to work through the elements that I ended up listing off. Those elements are going to be, as mentioned, whether there's compliance with the statute of frauds, the intent to bind, touch and concern. This is only a benefit, so we only need to talk about those 3 elements: compliance with the statute of frauds, intent to bind, and then touch and concern. All 3 of those elements were met in this case. But this case did end up going to examine the other parts of the elements: the notice of the covenant, horizontal privity, and vertical privity. All of these elements were met, and so there was a remedy that was required for this case. What are the remedies for real covenants? This is ultimately where things get pretty interesting as far as the main difference between a real covenant and an equitable servitude, which we'll get to in just a minute. As far as real covenants go, the remedy for a real covenant, I believe, is damages. And the remedy for equitable servitudes is an injunction, preventing them from doing that. So why did they go for a remedy of damages in this case? Why did they say this was a breach of a real covenant? It's because the houses were already built at 30 feet or higher. They had already breached it. You can't get an injunction against it, so you want to get that damage. And so ultimately, you're trying to prove that more elements are met than what would eventually happen with an equitable servitude. So let's talk about the difference between the equitable servitude and a real covenant. And really the difference is what elements need to be met to have a equitable servitude and the remedies that are available for these equitable servitudes. So just going through the elements one more time for a real covenant. For the burden to pass to future successors for a real covenant, it needs to be in writing, it needs to have intent, it needs to touch and concern the land, it needs to have notice, and we need to have both horizontal and vertical privity. Now for the real covenant, for the benefit to pass, we only need the writing, the intent, and the touch and concern. There's no need for notice, horizontal, or vertical privity. Now for the equitable servitudes, let's talk about the burden for the equitable servitude. Writing or a common plan needs to be met for the burden. Intent, touch and concern, and notice. There's no need for horizontal or vertical privity to be shown. Now for the benefit, we only need to show writing, intent, and touch and concern. We don't even need to worry about... We do need to worry about touch and concern. No need to worry about notice, horizontal, or vertical privity. And as I mentioned previously, the remedies for real covenants are breach of damages, and the remedies for an equitable servitude is an injunction against use. The whole point of understanding these differences is so that when you're drafting documents, when you're selling, when you're providing interest in land, you can provide an opportunity to recover in multiple ways. You can write in the chance to recover damages through real covenant, or the chance to provide an injunction against through an equitable servitude. And that's ultimately the whole point. Sometimes you might want an equitable servitude just because you want that injunction to prevent somebody from doing something so that the land is more marketable. Or you need the real covenant because there's already been damages that have occurred and you can't stop that. So you need to recover those damages. Let's talk about the restatement approach. The restatement kind of combines the real covenants and equitable servitudes into one doctrine instead of two separate doctrines. And this is called the covenant that runs at law. And the elements that need to be met, there's only three. First, there needs to show the intention to create the servitude that burdens the property. Second, there needs to be conveyance that meets the statute of frauds. And third, the servitude is not going to be arbitrary, unconstitutional, unconscionable, or violate any certain public policies. So that's the restatement approach. It's kind of a combination between the two, kind of combining those elements. Once again, I want to sum up these equitable servitudes and real covenants before getting into common interest communities. How's this all work? When somebody sells you land, they're going to put restrictions on that land for you to use it in a certain way. Can't build a shed, can't build a fence. You can plant trees, you have to plant trees. There's going to be all these restrictions, and it's to provide a benefit to the land and to one landowner and a burden onto one other landowner. And so now the question that we're asking is, do these benefits or burdens run to future successors? And so now we need to establish the relationship. We need to say who has the benefit, who has the burden, and then we need to work through the required elements for both a real covenant or an equitable servitude, depending on what kind of remedy that we want to have satisfied. And once again, those elements are writing, meaning the statute of frauds, intent to pass to future successors, touching concerned land, provide notice, provide horizontal and vertical privity. Those are the elements, and depending on what you're asking for, depends on how many of those elements need to be satisfied. Let's focus on common interest communities. These are called CICs. It's a group of residential housing that is going to be subject to restrictions, and it's going to be regulated by an HOA, homeowners association. People love or people don't like HOAs, and I think there's a variety of reasons there. HOAs provide unity for the community, make communities look nice, but at the same time, they can be pretty restrictive in a couple of weird ways that people are just not a big fan of. So, CICs, common interest communities, how are they created? They're created by a declaration, and this declaration is a document that has 4 parts. It's going to establish an HOA. It's going to talk about the CC&Rs. These are going to be covenants, something, and restrictions. I can't remember what the second C stands for. It's going to outline the financial dues that are made to the HOA, how much you need to pay each month. And then it's going to talk about the ownership rights of residents. And these are going to be that homeowners have a fee simple with an undivided interest in a common area. And these common areas include like a swimming pool or a community center. And if you get into the really, really nice CICs, they're going to have like golf courses, mountain resorts, and things like that. Now the question is really going to come to, well, if you don't like what the HOA is saying, how are you going to enforce the restrictions? Or can the HOA enforce restrictions? Can you get away with not following those restrictions? And there's 3 main ways that you can get away with not following those restrictions. If the restriction is unreasonable, you don't need to follow it. If the HOA abandons the restriction, no need to follow it. And if the circumstances change in a certain way, then there's no need to follow that as well. In addition to these 3 main ways, HOAs can release restrictions the same way that you can release somebody from an easement. You agree that this person no longer, or this restriction is no longer in force. So let's go ahead and talk about unreasonableness and how it functions, how it works. We have 2 cases here talking about unreasonableness. I can't pronounce them. I'm going to try. The first case is Nardstedt versus Lakeside Village Condos Association. And we're given the outline of what is considered unreasonable. First is the restriction arbitrary? And you can tell if it's arbitrary if there's no rational relationship to the purpose or the preservation of the property in question. Second, we're going to see if there's any harm that outweighs the benefit. And third, we're going to see if the restriction violates public policy. Those are factors that are going to be weighed to see if the restriction is unreasonable. In this instance, it was a restriction on pets within the property. This was a cat lady who loved her cats, but there was a restriction on having pets in the property, and HOA wanted to kick her out or the cats out. Since she couldn't get rid of the cats, she ended up leaving the condo. But she fought against this, saying it was unreasonable, and the court said that this was a reasonable restriction because it was arbitrary. It was not arbitrary. There was a rational relationship to preserve the property. Animals can destroy things sometimes. Generally, not saying her cats did, but generally, animals do. The harm outweighs the benefit. Here, I'm not sure what happened in this case as far as that element goes. And then violating public policy, the court didn't find a significant violation of public policy through this. We do have a second case, though, where it's kind of the opposite, where the court found it unreasonable to require tenants to maintain a clean interior of their home. Ultimately, it's a parent, as if they're talking to their kid, telling them to clean their room. And so the court finds that unreasonable. And so we can compare the two cases of pets unreasonable, telling you to clean up is pets is having a pet restriction is reasonable, while telling people to clean up is unreasonable, and how those two kind of relate. Our third case is Fink v. Miller, and it's talking about abandonment. This is the second way that a restriction may not be enforced. The standard for abandonment is if there's a violation of the restriction, if that violation is so great as to lead the mind of an average person to conclude that the restriction is abandoned, then the restriction will have no effect on the claimant seeking to avoid that restriction. So, how do you know if the violation is so great as to lead an average person to conclude that it was abandoned? We're going to consider the number of people who violates, and we're going to look at the nature and the severity of the violations that are occurring. In this instance, Fink v. Miller, it was a roof, and there was a roof restriction. You can only have wood roofs, but there were several homes previously who did not have a wood roof, and so Fink didn't want a wood roof, but the HOA was requiring them to have a wood roof, and they ended up building anyways, and claimed that the number of other homes was abandoning that restriction. Our final case related to the restrictions is Vernon Township Volunteer Fire Department versus Connor. And this is focusing on the changed circumstances. The standard for a changed circumstance to no longer have effect is the circumstances needed to have altered the event so much that there's no longer a substantial benefit intended by the restriction that extends to owners through enforcement of that restriction. This case, the changed circumstances were not sufficient to actually say that the restriction was no longer in effect. Two more things I want to talk about with the CIC is the actual governing document, and then we're going to be talking about some nuisance related to it as well. As far as the governing document goes, the HOA has certain responsibilities. The governing document establishes the HOA, and the HOA's job is to maintain common areas. They're supposed to make sure that the restrictions are enforced. They can amend and supplement the restrictions. They collect assessments. Those are the fees, the monthly dues. And they can do anything else that is administrative. But if you want to challenge the HOA's authority in this document, well, then you need to show that the HOA was not applying adequate business judgment. Typically, the courts are going to defer to HOAs and their business judgment if you want to challenge an action that they're doing. As long as the HOA is acting in good faith, the courts aren't going to question it very much. Acting in good faith for the community, that is. In the case that we had, it was Schaefer versus Eastman Community Association. There was no express violation of the covenants, and so the courts didn't want to interfere with the good faith reasoning and that the HOA had done for the benefit of the community. So let's go ahead and talk about nuisance. You know what, I think I might save nuisance. And actually, let me see. Yeah, I'm going to save nuisance for the next episode. This has been going on for a while anyways, so I'll I'll stop there. I just want to sum up the three things that we talked about related to land use restrictions. Notice that nuisance, you know what, I'm going to talk about nuisance because this is an overarching discussion about land use restrictions. Nuisance is a land use restriction, and so I'm going to focus on it in this episode. And so let's talk about nuisance, and then I'm going to go ahead and sum everything up. The restatement, second to torts, nuisance is a tort doctrine, but it can be applied and is applied to property. Section 821 defines a public nuisance as a non-trespassory invasion of another's interest in the private use and enjoyment of the land. So to prove nuisance, there needs to be 5 elements that are meant. First, the actions need to be intentional. And these are going to be the person with the nuisance is acting with a purpose or has a knowledge or they are certain to know that their actions are going to have a harmful result. That's intentional. The second element is non-trespassory. So this is a no physical entry into the land. If there's physical entry, this is going to be a trespass, but non-physical is going to be non-trespassory, which is a requirement for nuisance. Third, the actions need to be unreasonable. And their courts typically have 2 different standards that they may approach. The first is going to be a gravity of harm standard, or they're going to weigh the gravity of harm versus the utility of conduct. Our next case is going to talk about this, so I won't expound more onto that just now. Fourth, we're talking about substantial interference. That's going to be the invasion of the property's interests. They have a goal with the property and interfering with that in a certain way. And specifically, interfering with the use and enjoyment of the land. So if I were to sum these 5 elements up into one sentence, I would say nuisance are intentional acts onto a non-trespassory property that is unreasonable and substantially interferes with the use and enjoyment of the land. It's kind of a mouthful, but those are the 5 elements kind of summed up in a sentence. I think the restatements 2D is also a good way of saying those elements, where it says a non-trespassory invasion of another's interest in the private use and enjoyment of the land. Our first case is Boomer versus Atlantic Co. And this is, I'm talking about the elements. For the third element, which I mentioned was unreasonable, we've got 2 different options. We've got gravity of harm, or we weigh the gravity of harm versus the utility of conduct. The court in this case only applies the gravity of harm. What that means is they only care that harm occurred to the plaintiff. They're not going to weigh the benefit versus the utility. Interestingly, though, they do kind of weigh the benefit against the utility, but they do care that harm had occurred in the situation. So what's the remedy for a nuisance? Are we going to pay damages, or is the court going to provide an injunction? When the court recognizes that a harm has occurred, they're going to say that an injunction needs to be provided, but in a situation where there's a lot of utility, damages may be paid in lieu of the injunction. So that's going to be the benefit or the remedy available. Our second nuisance case was Thompson versus Grieve. This was a situation where neighbors turned south pretty quick. They used to be friends, then they got pretty sour. And shortly after being sour, there was smoke that was coming from one of the neighbor's chimneys, and the neighbor was claiming that the smoke was filling their house, taking up their space, and was super annoying, and in fact was causing asthma to occur. And so we're questioning, is that smoke a nuisance? Well, let's go ahead and walk through the elements. In this case, the court is going to apply the third element, where we're going to do a balancing test, the gravity of harm outweighing the utility of the covenant. Now, when we're using this gravity of the harm outweighing the utility of the conduct, there's 5 factors that the courts are going to consider, at least for the harm part of things. For the harm, they're going to consider the extent of the harm involved, the character of the harm involved, the social value that the law attaches to the type or use of enjoyment that is invaded. They're going to examine the suitability of the particular use and enjoyment that is currently being invaded to the character of the locality. And finally, they're going to look at the burden on the person harmed or avoiding the harm. As for the utility, there's only 3 factors. We're going to look at the social value that the law attaches to the primary purpose of the conduct, the suitability of the conduct and the nature of the locality, and third, the impracticability of preventing or avoiding the invasion. In this present case, the plaintiffs were awarded both an injunction against the air and against the smoke, and they were awarded damages for the harm that was occurring. And so that's nuisance. So let's go ahead and sum up once and for all land use restrictions and how they work imposed by the court. First, we talked about real covenants, and then we talked about equitable covenants, the elements that are associated and the remedies that are available. For a real covenant, the remedy are damages. For an equitable servitude, it's an injunction. The restatement approach kind of combines the two. And then we talked about common interest communities, the purpose of a CIC, the HOA, what the HOA does, how to enforce the restrictions, how to not enforce the restrictions, how to challenge the HOA, and associated topics. And then we talked about nuisance, the 5 elements for nuisance, the definition of nuisance, and then the difference between the gravity of harm application for unreasonable use and the balancing test between weighing the gravity of harm and the utility of the conduct. So that was a lot. I'm glad I made it through it. We've got 3 more episodes, I believe, of property, and then we're calling it. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.